These are appeals in the matter of Seculink Limited and Interbay Funding Ltd and Forbes.
Yes, good morning. Now, Mr. Cunningham, you're here today on for the appellant.
That's correct, in the Interbay appeal.
In the Interbay appeal. Mr. Westgate, you're here today
for the appellant in the Seculink appeal.
In the Seculink appeal. Mr. England, you're here for in the respondents in the Interbay appeal, and Mr. Morris, you're here for this one in the Seculink appeal. Have you had a chance? There was a direction for it that you draw up a timetable. We haven't received it. Have you complied with that?
I'm sorry, my lord, we didn't, but we have agreed a timetable.
Okay. What is your timetable?
It assumes a 4:30 finish, and I appreciate the court may not be willing to do that, but the timetable for a 4:30, if it's not convenient, we can always cut down our submission.
Why don't you tell us what you've agreed, and then we'll see where we are.
I'll speak until 12 noon. Line friend Mr. Westgate will speak until about 12:45.
12 noon, 12:45.
The respondents between them will speak until 4:15 at the latest, and then we will limit our submissions and reply between us to 15 minutes.
Right. Well, let's see how we go. The other preliminary point is on the Seculink appeal. We're dealing just with the third ground.
Just ground three, it's just the moratorium debt.
So, what occurred, I wondered about in my simple-minded way, Mr. Westgate, is how does that work with two other grounds floating in the background on jurisdiction?
It means that if we end up dealing with those jurisdiction points after this appeal is disposed of, which would be the case, it'll be against the background where we know the answer to the jurisdiction point if it had been resolved. And so if it may be that if the jurisdiction point goes in our favour, then that may have a bearing on whether it's academic or not to pursue those appeals, because there'd be but if it's but otherwise the jurisdiction point would still be a live one. It's just
sorry. Just explain that to me again. You mean if you succeed,
if we show
on the ground, today's ground,
yes,
then
the jurisdiction point isn't that the court had no jurisdiction to. Well, in this case, the jurisdiction point is along the lines that the court had no jurisdiction to go behind the decision of the debt advice provider that it was a moratorium debt.
Yeah.
So if this court decides that it was indeed a moratorium debt, then there's a symmetry between what this court decides and what the debt advice provider decided, and it may not then be necessary to go into the jurisdiction argument at all. If this court decides that the debt is not a moratorium debt, then the jurisdiction argument will remain a live one, because the point about the jurisdiction argument is that the court shouldn't have asked the question right or wrong, and so it may have a bearing on the precise order this court makes, but it doesn't render the jurisdiction argument academic.
What happens if you lose this appeal on ground three, but you then win your appeal on jurisdiction, so that the result is that a later court will have decided that this court had no jurisdiction to make the decision which it's made? What happens? Does a later court set aside our judgment? And if not, how do we stand with two conflicting decisions which are irreconcilable?
Well, it may be that using the term jurisdiction is not necessarily the right term, because the thrust of what I'll continue to call the jurisdiction point in the Seculink appeal is that the court can't or shouldn't exercise any power it would have to decide the terms.
But whatever you call it, whether you say it can't or shouldn't, it would have decided.
Well, it's doing so here in the context of an appeal where the point is before it in another appeal. And so we've joined this argument to be heard on that issue. It's in that sense, it's a point where the court's already seized to the point.
What would be the impact of a decision that on a subsequent appeal that this court had, or the court had no jurisdiction? What would be the impact of that on the other appeal?
Well, the appeals aren't symmetrical in that sense, because in the Seculink appeal, the debt advice provider decided that the debt was a moratorium debt, and the creditor had an opportunity to challenge that and didn't take it. And so the argument is that when a creditor seeks to challenge the inclusion of the debt, then they have to follow that exclusive procedure, and whether one calls it jurisdiction, whether one calls it discretion, or whether one calls it abuse process, that's the thrust of the argument. In the Interbay appeal, the position is different, because the argument is, there's a dispute about it, that the debt advice provider did the opposite in that case, and that they decided that the debt wasn't a moratorium debt, and so that raises rather different issues. So
Is your jurisdiction point? It's not the court doesn't have jurisdiction. It's just that it only has jurisdiction pursuant to a different route. That is, if the DAP makes a decision, which can then be appealed to the court. Is that right?
It can only entertain a claimant's challenge, or rather a creditor's challenge, via that route. Is the
On appeal to the court, what's the court's power on an appeal from a decision by the DAP?
well, it's got all the powers of the court below.
I'm thinking of the court below. So on the application to a court to appeal the decision, to challenge the decision of the DAP, what can the court do?
It triggers the powers under Regulation 19 of the regulations, and the court. The process is you apply to the debt advice provider for a review under Regulation 16, and there are various grounds which include unfair prejudice, and they include that the debt isn't a moratorium debt. If the debt advice provider cancels the moratorium, then it stops there. If they don't cancel it, then you go to the county court on appeal, and the county court on appeal has in effect the same powers as the debt advice provider on review. There are some variations, but
the powers, aren't they, are merely to cancel the moratorium or cancel the moratorium in respect of a moratorium debt.
That's right.
Where's the power to decide it was a moratorium debt?
Well, it's in the course of making that decision, because one of the grounds on which you can cancel a moratorium debt is that it wasn't a moratorium debt after all.
Cancel the moratorium in respect of any other moratorium debt.
Well, that's one of the anomalous readings of the regulations that arises on that point, that if the creditor's argument is right on that point, then it means that the references to moratorium debt have to be modified in some way in those regulations. But certainly one of the grounds is that a debt included in the moratorium is not a qualifying debt. And so the county court can decide that question. If it decides it in favour of the creditor, then they will almost inevitably cancel the moratorium.
Anyway, is there anything else you want to say about the position that we're in? As you can probably tell, we're a little uneasy.
Yes. There isn't. I'm not sure there's a.
I mean, you're not in a position to argue grounds 1 and 2 today on a permission application.
No, and it would derail this day's hearing, because there's quite a lot to it, and certainly you don't have the authorities that we rely on.
My Lord, sorry, there is a slight complication. Can I mention something else? Which is that in the Interbay appeal, the respondents have raised a jurisdiction point against Mr. Forbes in the respondent's notice.
Yes.
That's at page tab 3 of the page 27 of the Interbay 4 bundle.
Sorry, would you give me that page number again?
Sorry, 27, tab 3,
Yes.
page 27.
So which paragraph did you say? Which paragraph?
Paragraph 2 is the first ground.
Yes.
There's also a slight complication in that Mr. Forbes in Seculink appeal argues for jurisdiction point, and in an Interbay appeal he argues against it, relying on the judgment of Sir Anthony Mann.
Yes.
I just wanted to draw that to your attention because that seems to be relevant to the.
Yes.
My Lord,
You
I'm
want to say
sorry,
something?
Sorry, Judge. As Mr. Westgate explained, it is not the same point with jurisdiction. There was a jurisdiction ground similar to the Seculink that we hadn't applied to the court after the review by the debt advice provider, but that was dismissed by the judge. It was ground 5 below, and it's not being pursued by Mr. Forbes in our appeal. In terms of my respondent's notice, as Mr. Westgate indicated, it's different because what we're not saying the court doesn't have jurisdiction. We agree that the debt advice provider is the arbiter of what's in and out of the moratorium. And we say on the facts of this case, they decided the called-in capital was not in the moratorium and did not register it as such, and therefore it's not a moratorium debt under Regulation 6C. So it's a different, when Mr. Gunn-Cunning says jurisdiction, it's not the same jurisdiction point that's being run in Seculink. So we say that is something the court could decide today.
Okay.
Before Mr. Clark's drawn my attention to a practical way forward, although it does impose burdens on the court. One would be that we hear the moratorium debt point today, but expedite the jurisdiction point for the court, whether this constitution or another constitution, to deal with that point before judgment's handed down on this point.
So expedite. This will be on a permission application.
Well, it probably makes sense to have a rolled-up hearing on it.
Yes.
Because,
And how would you suggest we expedite it?
well, it's
Would it be helpful if, having raised this point, if we rose for a few minutes quickly, so you can decide, just have a think about how you might do that. We are anxious about this extremely loose end, and we want to resolve it as far as possible. I should say that we have all read the papers very thoroughly, and we think we're on top of the issue. So it may well be, and Mr. Gunn-Cunning was going to take us through the regulations in some detail, and it may well be we can move rather more quickly when we get to the substance than you thought. Should we do that?
yes, well, 5 minutes at most.
Yeah, I mean, we will be grateful for some practical solution as to how we can
Yes.
to the issue. Thank you very much.
What rise available?
We're not saying, for example, the JR couldn't decide the question. We're saying that on the challenge by the creditor.
Yeah, the creditor only has
Yeah.
that one room.
There's no housekeeping.
And you can hang me with it. Yeah. I mean that was my. I think the preferable solution would be that this court hears it on an expedited basis, rolled up, and then gives a single judgment for that.
Yeah.
As if we'd have had a 2-day hearing.
Does that then mean that we hear Julian's jurisdiction point at the same time? So we'll just spend today dealing
with the interpretation.
with the interpretation of it.
I mean,
make it would make it a slightly bizarre hearing from.
These regulations.
Yeah.
I mean, the fallback would be, as you say, that that another constitution here's the jurisdiction ground, gives judgment on that, and then these give judgment on. But I mean, that seems messy. Definitely the preferable solution is that they hear everything. Yeah, exactly.
Well, yeah, that's obviously preferable, but
it depends on them.
Yeah, exactly. But do we also say though that Julian's jurisdiction point goes in the mix? I think
Does that present any issues in terms
Well,
of the client instructing you and paying for
it
another day in court?
does present problems because we're in conflicting positions as the same client. But we know that's a problem.
Well, they're not conflicting because they're slightly, we say
Well, slightly.
it's because the creditor has a particular route and the debtor doesn't, so it's not a kind of true jurisdiction point. But because you're not, is your might your funding be an issue that if you don't argue it today, you
My funding's an issue anyway.
All right.
should we get Joan to
Yeah, I think you might have just
yeah. So what we're suggesting is same constitution if at all possible.
Yeah.
Here, well, I think clarify that when we say jurisdiction, we're not saying that the court can't answer the question.
Yeah, it's just that it shouldn't do.
Yeah. Yeah. So but in terms of practicalities, this constitution hears this before it gives judgment on this point, and it gives judgment together.
I think that's right on the practicalities. In relation to the nature of the jurisdiction point, does that then mean grounds 1 and 2 almost into each other, or is there still a kind of distinction between?
I think I think abuse is slightly different from exclusive jurisdiction. I think
Exclusive,
I
yeah.
think
your
suggestion is the only one.
I think so. I'm afraid.
Yeah, but are you happy for your jurisdiction?
It's not jurisdiction.
I know you keep calling it
Stop
jurisdiction,
saying jurisdiction.
Yes, for the reasons I gave.
The procedural challenge.
Yes.
To go to the other hearing, so that we have more time today on this, or that's what we thought would be the sensible division of.
And I'm not sure you can divorce it because I think it's not the same. It's not the same point. It's different.
Well, I think the question really is whether those 2 points should be heard together, or whether you should have your one heard today as part of the.
Well, I think we should be there today because it's a different point.
Okay, well that's.
But if the court disagrees with that, then we can roll that with your one. It's just cleaner than all of ours.
I guess because if yours is heard today, you don't need to take part in the other hearing, do you? Because you've got nothing left, which I guess is. There's arguments both ways. I mean, thematically, it makes sense for the two to be heard together, and practically, it probably makes sense.
Realistically, if it's going to be the same appeal, and the same judgment, we're going to want to.
You're going to want to be hearing.
Well, that's a fair point too.
That is true. Yeah. But I'm kind of almost there.
Sorry.
We just decided, the Benny has whatever. I don't know.
No, I know. It's. I was expecting lots of questions on this point, but not this one.
You want to hear it tomorrow?
Look,
Did ask for 2 days.
Okay, well, should we ask the court to come back in? Yeah.
The court's ready? Court rights available.
Well, we've had some thoughts as well, Mr. Westgate, but you go first.
Well, first of all, just to clarify the point about the sense in which we say this is a jurisdiction point, we're not saying the court doesn't have jurisdiction to decide the issue at all. So, for example, it could do on a judicial review application if it was an issue in the judicial review. So the nature of the jurisdiction argument is really about the extent to which a creditor is entitled to raise the issue when.
Yes.
But I don't know if that makes any difference. In terms of practicalities, what we would invite this court to do would be to hear the issue today, and then, if at all possible for this constitution, to hear a rolled up hearing of the Seculink jurisdiction point, and then to, if possible, hand down judgment on both points at the same time.
What we thought, Mr. Westgate, we would do would be to focus on the issue as listed today, and then to consider your application for permission to appeal on the other grounds, initially on paper.
Yes.
Which would give us the option, if we thought it appropriate, to list it for either a permission hearing or a rolled up hearing, or to grant you permission, the full range, but to deal with it first on paper, and to give the respondents, which is you in this case, Mr. England, have you filed a response to this under paragraph 19?
My lord, we haven't. No.
Would you? So we would give you the opportunity to do that. Does your skeleton argument fully cover this
Yes,
issue?
it does.
So you don't need to file anything else, you think?
I don't think so, no. But can we?
Well, do you want to have a think about that over the short adjournment?
Exactly, and then if
And if you
anything-
wanted to,
yes.
then we give you a few days.
But
to
I
do
don't
that.
think we do.
No, it seemed to me that it was covered. It's not a very complicated point in your skeleton. And then you could have 7 days to, or maybe 5 days. We'll see how we felt to respond, and then we would deal, and then we decide what to do. So if we were against you, one end of the spectrum, we will deal with that in the judgment on the basis of the written documents. If, however, we thought that the matter permission should be granted, or that there should be a rolled up hearing, as you suggest, then we would list the matter for a further hearing, and it would be the full constitution, this constitution that would deal with it.
Yes, can I check with Mr. Clump? Yes, we're in agreement with that as a way forward.
And I don't know what you would want to do, what Interbay would want to do about that, whether they want to have any say in that.
I could take instructions, but I think on the current plan, we would dispose of our appeal to today,
Okay,
which
fine.
would save us potentially
All right.
turning up.
Good. Well, we've lost 25 minutes, but let's see if we can catch up. Yes, Mr. Gunn Cunningham.
My lord, what I just want to check. There are core bundles and supplementary bundles in each.
Yes, the bundles look pretty good in this case. May I say so? They've been well prepared. Thank you very much.
And 2-volume joint authorities bundle Interbay appeal, and one authority bundle in the Seculink.
Correct. Got 3 authority bundles.
What I was proposing to do, my lord, was to make some brief submissions on statutory interpretation.
Yeah.
Go through sections 6 and 7 of the Financial Guidance and Claims Act 2018 and the regulations. Go through grounds 1 to 3 in my appeal. Mr. Westgate is dealing with regulation 5.4a of the regulations, which I'll take you to when I go through.
Right.
And then finally, I'll deal briefly with the points raised in the respondent's notice.
Good.
Dealt with in my skeleton argument, if there's time to say something orderly.
Thank you very much. Right.
So Mr. Westgate's going to deal with principle of legality on
Yes.
statutory interpretation, because that's raised more in the Seculink.
Yes.
appeal. So what I was going to do, my lord, was take you to the Seculink, sorry, the Interbay Authorities Bundle, volume 2. Tab 19.
Yes.
Page 401.
So this is.
Benyon.
Yeah.
Rather than reading out, can I just invite you to read certain passages?
Yes.
So 317 and the comment and delegated legislation, but not the example.
Do you want us to read that now, or just
You
mark
don't
it?
need to read it now, but
That's your point. Your preliminary point.
Yeah.
Delegated legislation is dealt with the same way as any act.
Yeah.
Right.
and then take you to page. Then also over the page, not to read now, interpretation in favour of validity. and restrictive interpretation of certain provisions. And at the bottom of the page, meaning of expressions derived from enabling act over the page, and quality of drafting.
Yeah.
And then page 404, 21.2, the one line, there's a presumption that everywhere in that was given meaning, and the comment underneath, but not the example.
Which page was that?
Sorry, 404.
Thank you. You say that this is a provision which is given a restrictive interpretation, as Benyon says on page 402? Does this fall within that category?
I don't, but I think it rises more in the Seculink appeal. But I was just drawing that to your attention as I was going through it, so that you had all the references.
Yes, thank you.
And then page 405, no sensible meaning in surplusage passage. There is some difficulty in the meaning of these regulations, so
Yes.
I thought that might be relevant. And over the page overlap, the one line. And then on page 407, guidance of official statements by minister on what the persuasive authority is the legal meaning of that, depending on the course of the reason. There is guidance in these regulations, so I'd like to read the guidance section. And other official statements on page 408.
Yeah.
In the Seculink Authorities Bundle, tab 7, page 141. I'm going to ask you to read, again, not now, section 11.6. And the comment underneath it. Page 142, opposing constructions.
Sorry, I'm on 141.
Yeah, so on 141, section 11.6.
And the paragraph mark, the comment mark. Yeah.
Yeah.
Thank you.
And opposing constructions over the page 142. Consequences both ways, 143. And ambiguity and constrained construction. 11.7, page 145. Interpreter to use common sense. 146, 13.5, avoiding an anomalous or logical result, but not. Page 150, new statutory scheme. As marked. And that's it.
Well, we've gone through those at quite a gallop. Do you want to ask any questions about that?
I mean,
Tony, do you want to ask any questions? Thank you.
the principles that your lordships will be familiar with, I just drawing your attention to them, reminding you of them.
Well, thank you. It's very helpful.
I mean, you'll tell us when you get to the regulation which of the principles you've just referred us to bear on the point we have to decide, presumably.
If I could then take it to the Seculink Authorities bundle.
Seculink authorities.
Sorry, the Interbay Authorities bundle.
Yeah. Volume 1 or 2?
Volume 1. Tab 2. Sorry, tab 3.
Tab
Page-
3.
Tab 3, page 17. So this is the act that governs the regulations, and section 6.1, Secretary of State must within 3 months establishment of a single financial guidance body seek advice from the body on the establishment of debt respite scheme. 6.2 is something I rely on particularly, is the debt respite scheme is designed to do one or more of the following, A, B and C, and I refer to that in my skeleton argument.
Yes.
And then subparagraph 3, the matters on which the Secretary of State may seek advice include, but are not limited to, C, the scope and design of the scheme, for example, and then Roman 1 to 5.
In subsection 2A, what is the significance of the word further from the accrual of further interest or charges on their debts?
I take that to be post-moratorium interest.
Interest on what?
On their moratorium debt.
So interest on the payments which have fallen due before the moratorium but have not been made, or interest on the capital, i.e. ordinary periodic payments?
Well, it could mean either, but
Do you have any submission as to which it does mean?
well, because it's a protective mechanism, it's designed to. I would say it's the latter. It's to protect accrual of further interest on payments falling due during the scheme.
Accrual of further interest.
Yeah. Yes.
So in a sentence, what does that mean?
Liability to pay interest.
Your case, isn't it? This is a £300,000 interest-only mortgage in existence. For the period of the moratorium, no interest accrues on that debt. That's your case, isn't it?
My case is that the whole of the called-in loan is a single debt, and that no interest. It is a moratorium debt, including the capital element of it, and no interest accrues on it during the moratorium.
Only if it's been called in.
Yes.
If it's not been called in, interest continues to be payable throughout the period of the moratorium.
Yes, the payments due would be payable. Yes, the instalments under the loan would be payable. Section 7, page 18. As soon as reasonably practical, after receiving advice from the single financial guidance body, the Secretary of State must consider whether to make regulations under this section. And after receiving advice from the single financial guidance body under Section 6, the Secretary may make regulations establishing a debt respite scheme. The regulations must take the advice into account. The regulations must provide for the scheme to apply and they apply in England and Wales only. And the advice that was given is in the bundle. The Seculink Authorities Bundle at tab 8, page 174. And I was going to draw your attention to the policy at page 179. Defining policy objectives and intended outcomes. Do you mind reading that? And I was going to take you to the regulations themselves.
So far as the principles from Benyon you put us to earlier are concerned, what status do we give to this advice in terms of interpretation?
Well, it's advice to a government minister as part of the preparation of secondary legislation, so you do take it into account.
If we do take it into account, what exactly do we get from it?
The policy objectives are essentially the protection of individuals in debt to enter sustainable debt solution. I think it's the first time that appears.
Does that help us one way or the other to decide whether it was a policy objective to include or exclude the capital?
It does, because, my lord, if a capital is called in, that called in capital is part of the portfolio of debt for which a debt solution is required. If a capital has not been called in, so it's continuing, the agreement's continuing to be paid by instalments, then that's not something that requires a debt solution, because that's not an immediate debt problem. And also, in the second limb, a called-in loan would expose an individual to recovery and enforcement action, whereas a non-called-in loan would not. And the third limb, to increase access to and awareness of debt advice. Debt advice would be required for a called-in loan, but not for a not called-in loan.
If that's the case, it's a liability that the individual is facing. It's a liability that the individual is facing, whether it's been called in or not. They still need advice in relation to their affairs generally, including that liability.
Well, they would. I accept that, but they would. It would not be in terms of managing their payments. I accept that. In terms of dealing with immediate debt problems, in terms of facing enforcement action, they wouldn't. They would require more urgent advice on called-in loan than a non-called-in loan.
The page you took us to on 179 was under the heading Evaluation Considerations.
Yeah.
And it includes a recommendation that the policy objectives be defined. We can read what it says there. But it then says the government has helped to provide some steer in those respects. And we've built upon this to suggest the following policy objectives. Are these policy objectives based on anything the government had said prior to this document? Does it suggest it might be?
I don't think there's material in the bundle to that effect.
This was a response to a letter dated the 17th December 2018, which I think we haven't got. But that's it.
Could I take you to the regulations themselves, which are in the Interbay Authority Conduct Volume 1, tab 4. Page 19, Regulation 1.2, these regulations come to force for the most part on the 4th of May 2021.
Were these, to what extent was this a COVID-related regime?
It wasn't at all. It was part of the 2017 election manifesto of the Conservative government under Theresa May.
Thank you.
There is material to that effect. I'll draw your attention to due course.
Well, don't worry about that. I don't want to take you off course. So go.
I could probably do that now. So I think it's in the House of Commons guidance. Just can't lay my hand on it.
We'll come back to. I've distracted you. I'm sorry. Come back to it in due course. Mr. England may be about to help.
So the interpretation section is Regulation 2. And I was going to draw your attention. They go very beyond the side lining to relevant provisions. Some of them are just signposts to regulations. If I could just draw what I regard as relevant to understanding the regulation. So additional debt, approved mental health professional, arrears is very important in the scheme of ground 1 of our appeal, ground 3 of the Interbay appeal. breathing space moratorium, capitalised mortgage arrears is also very important in our appeal. Debt advice provider on page 21. Debt solution. Debtor. Enforcement action. Regulation 7 is very important. 7.7. 22. Mental disorder means any disorder or disability of mind. Mental health crisis moratorium. Mental health crisis treatment. Moratorium. Moratorium debt. Moratorium period. Non-eligible debt. Ongoing liabilities which relates only to a standard breathing space, not to a mental health crisis breathing space. Secured credit agreements includes a mortgage on land. Secured debt is a secured credit agreement, a hire purchase agreement, or a conditional sale agreement. And then secured credit agreement goes back to the previous definition, including a mortgage on land.
Yeah.
Regulation 3.1 is a debt advice, the meaning of a debt advice provider. That's someone who's regulated under the Financial Services and Markets Act 2000 for debt counselling. Regulation 4.3, where a debt advisor provider accepts a referral of debt, they must, by the end of the following business day, provide a notification they have accepted the referral to the Secretary of State or debtor, as the case may be, or as the case may be, the debtor's nominated point of contact. Where the Secretary of State receives a notification from the debt advice provider in accordance with paragraph 3A, the Secretary of State must, by the end of the following business day, send a notification of referral to each creditor and agent who received notification of moratorium in relation to the debt under these regulations. A referral of a debtor to a debt advice provider takes effect in relation to the obligations under these regulations till the first business day following day on which the debt advice provider accepts a referral. So that's the way it works. It's an immediate notification once the debt advice provider accepts a referral. Regulation 5.1, a qualifying debt means any debt or liability other than non-eligible debt. 5.3, the qualifying debt includes any amount which a debtor is likely to pay under in relation to an order or warrant for possession of debtor's place of residence or business, a full judging or controlled goods agreement.
That's not in addition to the definition of qualifying debt.
There is, he's on a, sorry, that was argued in a county court case. In Bluestone Mortgages at Stout, and it was decided that it wasn't. It means that he was capable of including rather than actually including all such judgment debts. And then 5.4a is the point that my learned friend Mr. Westgate is going to deal with because it's quite complicated, difficult. In these regulations, non-eligible debt means secured debt which does not amount to arrears in respect of secured debt. And that features in all the judgments on this point.
Yes.
What that means.
What about the remainder of 5.4? There's a whole list of things which are non-eligible debts. Do you say we can gain anything, any idea or clue as to the interpretation of A from what's in the rest of it?
It's part of learned friend Mr. Westgate's submissions that in respect of, in D, and in respect of a fine, in respect of any sum paid, in H, any sum paid or payable to the debtor as a student loan, K in respect of council tax for financial year, and L in respect of non-domestic rates for financial year. That those all in respect of should all be read in the same way.
Right. But in terms of the subject matter of what's excluded, it seems to me, I haven't done a complete check, but everything that would be non-provable in bankruptcy or would not be discharged by the discharge of the bankrupt is within this non-eligible debt criteria. Is that right? And if so, is there any policy reason that was done? Is there any clue in any of this extra statutory materials as to why that approach was taken?
There is a reference to the a brief reference to the Insolvency Act. So this is in the House of Commons briefing, tab 21, volume 2 of the Interbay Authorities.
What page number?
440, towards the top of the page. I think it's the same point that my Lord Justice Zacaroli made about these excluded debts effectively mirror the debts not discharged in bankruptcy under the Insolvency Act 1986.
What's the status of this document in terms of interpreting the regulations?
Well, I would say very little, I think, because it's a post-regulation commentary on it, but it's the only reference that there is to the Insolvency Act that I'm aware of.
I think Mr. Morris disagrees.
So it's Mr. England, my lord. I
England,
apologise.
got it the wrong way around.
I wouldn't want him to get blamed for my any of my mistakes.
Sorry, you look vaguely alike. I'm Rosencrantz and Guildenstern, I'm sorry.
Hopefully not dead.
Hopefully not the same result, no. Yes.
I'm sorry to interject, but I think my learned friend invited me to. It is actually in a pre-regulations document, which is, you may have come across, the HM Treasury Explanatory Memorandum. And that's found in the Authority Manual at tab 24.
Yes.
And if one goes to paragraph 7.8, which is on page 533. 534, thank you.
So this is the expenditure memorandum to the regulations.
Yes, it's a 2019 document, so it precedes the coming into force of the regulations. And I don't think it's relied on. It was relied on by Mr. Westgate before Sir Anthony Mann in the Seculink.
It is, yes.
It was right. I don't think there's an issue about its admissibility in terms of, but it's before, and it's 7.8.
Yes.
And it makes the same point that Justice Zacaroli made, and that was in the later document, that there is a mirroring of the position in bankruptcy. I don't want to exceed my role, but there's also a reference in one of the cases, the decision of Mr. David Locke case. He's
Yes,
sitting as
you referred to that in your skeleton.
I did, my lord, and he picks up on the insolvency aspect, but perhaps I can address that when
we get to it. Thank you, Mr. England.
Just to clarify one point on that. It's mirroring the position in bankruptcy so far as some specific public sector debts are concerned, isn't it? Because it's the bankruptcy non-provable debts list goes beyond that.
Yes, including secured debt.
Yes.
Yes, I think there's the additional public reference, yes.
Sorry to interrupt.
So, Mr. Gunn Cunningham, you took us to the document at the scheme document, page 440, where the mirror
That's a House of Commons briefing.
House of Commons briefing. I turned back a page. Do we see anything of any relevance to the meaning of arrears in this context, or rather, non-eligible debt in this context? So we were looking at what
I think it's just it's paraphrasing what's in the regulation.
secured debt. Yeah.
I think it's just summarising what's in the regulation.
Yeah, so the second bullet point is any secured debt arrears that accumulates after the breathing phase starts are not protected. Right, well, Mr. Westgate's going to deal with that point. Yes?
While we're on this document, can I just refer you to page 427, first paragraph.
Yes.
That was the manifesto commitment.
Thank you.
And in 5.4b, reference to non-eligible business debt on page 25 of the volume 1. So volume 1 authority bundle.
Yes. Yes.
Non-eligible business debt is at B.
Yes.
And that's further defined at on page 27 at 6D. Essentially, where the business carried on by the debtor is registered under value-added tax, and the partner or a partner, the partnership of any other person, and the debt solely relates to business carried on by the debtor. Regulation 6 defines what a moratorium debt is. By debt in relation to whom the moratorium is in place, that was made by debt at the point at which the application of the moratorium is made, and about which information has been provided to the Secretary of State by a debt advice provider under these regulations. Regulation 7.
So an instalment falling due after the date at which the application for the moratorium is made is not a moratorium debt. Is that right?
That's correct, yes.
So if you have a mortgage and you have to pay monthly, and you make your application for a moratorium on the 1st of February, you still have to pay the instalment which falls due later in February and every other succeeding month.
That's correct, yes.
So you're reading the word owed as due and owing, are you?
Yes, that's what that is.
I mean, the regulations sometimes say owed and sometimes say fallen due. Is that the same, or is there a distinction?
Well, in the example that you gave, that would be they wouldn't have fallen due or owed. It's not part of my case that there is any distinction between fallen due and owed.
So a mortgage instalment that fell due after is not protected.
Yes.
And that's what it says in the seems to be what it says in regulation. Also what's said in this House of Commons document that you took us to on page 440, and I went back to page 439. Excluded debts includes any new secured debt arrears that accumulate after the breathing space starts, e.g. mortgage, hire purchase or conditional sale agreement arrears. So the capital, on your case, the capital sum is included, but any further instalment that falls due on that is not. Is that right?
On my case, there is a single moratorium debt, which includes the whole called-in debt.
Yes.
And interest and charges accrue on that. But that interest is then frozen by section 7(6)(a). So on Regulation 7, a moratorium has the effect specified in this regulation in relation to a moratorium debt during a moratorium period. Subject to paragraph 3, during moratorium period, a creditor may not, in relation to any moratorium debt, take any of the steps specified in paragraph 6 in respect to the debt, unless these regulations specify otherwise, or the county court or any other court tribunal, where legal proceedings concerning the debt and venal could be issued or started, has given permission for the creditor to take the step. 3, a court or tribunal may not give permission for a creditor agent to take any of the steps specified in 6(a) or B, and that's paying interest or paying fees, penalties or charges. Subject to paragraph 5, for the purposes of paragraph 2B, that's the permission. The court or tribunal may determine an application for permission to take a step specified in paragraph 6C or D in any way that it thinks fit. B, give permission subject to such conditions as it thinks fit, and make such orders as may be necessary to give effect to the determination of the application. In this case, possession proceedings before what we say is on a moratorium debt, without permission having first been granted by the county court. Regulation 7(5), court or tribunal may only grant permission under paragraph 2B for creditor agent to take a specified step. The step specified in paragraph 6C, or for creditor to instruct an agent to take a step specified in paragraph 6C, where the court considers that A, it is reasonable to allow the creditor or their agent to take the step, and B, the step will not be detrimental to the debtor to whom the moratorium relates or significantly undermine the protection of the moratorium. So that's the restriction the court has to take into account when it decides whether to grant permission or not. The steps that's mentioned in paragraph 6, regulation 7(6), the steps mentioned in paragraph 2 that the creditor is prevented from taking are any steps to A, require a debtor to pay interest that accrues on a moratorium debt during a moratorium period. Require a debtor to pay fees, penalties or charges in relation to a moratorium debt that accrues on during a moratorium period. Take any enforcement action in respect to a moratorium debt. Instruct an agent to take any of the actions mentioned in subparagraphs A to C. 7(7), the creditor agent takes enforcement action if they take any of the following steps in relation to moratorium. And in my appeal, the relevant sections are A, C, and F.
How does this work in a case where the debt has not been called in at the beginning of the moratorium, but the debtor has built up some arrears before the moratorium and continues not to pay instalments falling due after the moratorium. This means, does it, that the creditor can't enforce so far as the pre-moratorium instalments are concerned, but can do whatever he likes to enforce instalments falling due after the date of the moratorium? Is that how this works?
I believe so. The moratorium protects the debtor from prior debts and from interest on those prior debts, but not from continuing obligations to make payments.
So if the continuing obligation to make payment is not a moratorium debt, the debtor can enforce non-payment, including, if the mortgage so provides, by calling in the whole debt after the moratorium, so long as he is careful to confine the default on which he relies to the post-moratorium instalment. Is that your submission as to how this works?
That's Mr. England's submission, and I don't demur from it. It seems to me that's the way it does work.
Okay, thank you.
7.9 is again something I think Mr. Westgate's going to deal with, because it's again quite confusing, but I think he's got an answer to it. Is where a moratorium debt is a secured debt, paragraph 6A applies only to interest that accrues in the arrears on a debt during the moratorium period. Paragraph 7.10, after the end of a moratorium period, neither a creditor nor their agent is entitled to require a debtor to pay interest, fees, penalties or charges that accrue during the moratorium period, or treat non-payment during the moratorium period by the debtor of interest, fees, penalties or charges to default by debtor under a breach of agreement between the debtor and the creditor. Paragraph 12, any action taken contrary to this regulation shall be null and void. Regulation 10 deals with existing legal proceedings, and 5 to 8 essentially require the court to ensure that proceedings do not progress during the moratorium period. Regulation 11 prevents contact between a creditor and the debtor during a moratorium. Except for in the circumstances in 11.2. Regulation 14 requires a creditor to search for their records to identify any debt owed to the creditor by the debtor and any creditor by assignment, and then to provide the details to the debt advice provider. 4 is a penalty for not doing that. 5 requires any notification the debt advice provider then needs to deal with it as an additional debt under Regulation 15. Regulation 15 deals with additional debts that arise during the moratorium. Regulation 16 puts onus on any applicant, any person who makes an application to take reasonable care to provide accurate information. Regulation 17 is the creditor's right to request a review of the moratorium on the grounds that it unfairly prejudices the interest of the creditor as being some material irregularity. And regulation 17.2 sets out the three grounds for material irregularity. Debtor did not meet the relevant eligibility criteria. The moratorium debt is not qualifying debt. Debtor has sufficient funds to discharge or liquidate their debt. The request for for review must be made within 20 days, beginning the day on which the moratorium started, or for 20 days from when the additional debt was added. And must be made in writing and contain a statement of grounds and evidence. Regulation 18 deals with the review. Having requested a review in accordance with the regulation, debt advice provider must conduct the review and carry out the steps in paragraph 4 before the end of the period of 35 days, beginning the day on which the moratorium started, or when the additional debt was notified. And 18.2, the debt advice provider must cancel the moratorium if debt advice considers that the creditor supplies sufficient evidence that the moratorium unfairly prejudices the interest of the creditor, or there's been some material irregularity in the three items in 17.2.
If we just come back to regulation 16, page 34, paragraph 2b says that during a breathing space moratorium, a debtor must make any payment due in relation to an ongoing liability as it falls due to be paid during the moratorium period, which is consistent with what you've submitted so far. That's during a breathing space moratorium. I couldn't find, but please help me if there is something, any equivalent which deals with a mental health crisis moratorium.
No, there isn't.
Is there any, why isn't there? Why are the two to be treated differently, and if so, why?
Well, ongoing liability has a particular meaning, which is at page 23.
Yeah.
So it's well, A is on land used by the debtor as their primary residence. So it's for the 60-day standard breathing space. It is a requirement that they pay their ongoing liabilities as defined in that regulation. If they don't, the regulation is then cancelled for not paying ongoing liabilities. There is no equivalent provision in a mental health crisis because a mental health crisis is ongoing beyond 60 days.
What's the consequence of failing to comply with 16.2?
I believe that it's sorry, just I believe it's cancelled if you don't discretion.
Regulation 27.
Sorry, 27.5, page 40. This is a midway review, which doesn't happen in a mental health moratorium. A debt provider must cancel in respect to some or all of the moratorium debts if debt has failed to comply with any of debtor's obligations under Regulation 16.
mental health crisis moratoria are dealt with in this next part, aren't they?
Part 3, yes. On page 41.
So is there any equivalent provisions within that part to the
No,
ones you've been,
No.
Mr. England, I think?
I'm sorry, there isn't an express replica of 16.2, but of course the definition of moratorium debt in Regulation 6 and the definition of arrears limit themselves to debt up to the date of the application of the moratoria. So in that sense, that suggests that things that happen afterwards aren't caught by it, but there's no express replica of 16.2, which I think my Lord will just...
Well, one question which don't deal with now, but you may want to when you come to make your submissions, is if liabilities falling due after the moratorium aren't moratorium debts anyway, why is set in Regulation 16.2b needed at all? As I say, don't deal with it now, but it's just something I was wondering about.
So the structure is that a breathing space moratorium has a fixed period and a mental health crisis moratorium does not.
Sure.
That may be relevant to the interpretation.
Yes, a mental health crisis moratorium continues until the mental health crisis treatment finishes, and then plus 30 days after that. And then you could have a standard breathing space after the mental health crisis moratorium. You could have as many mental health crisis moratoriums.
Is there any reason, in theory, why a mental health crisis should not go on indefinitely?
Well, no, there's no reason why it shouldn't. But in this case, Mr. Forbes' mental health crisis moratorium started in July 2022, and every 20 to 30 days he is assessed and reported on to. And if that assessment doesn't take place, he automatically falls out of the mental health crisis moratorium.
So there's an onerous obligation to undergo review, but subject to that, it can be indefinite. So it's a different animal, isn't it? The mental health crisis moratorium. Yes,
and
thank
there's
you.
no midway review, obviously, because there's no midway point. In a standard breathing space, there's a midway review between in the 60 days. Another difference is that you can only have one standard breathing space moratorium a year, whereas you could have more than one mental health crisis moratorium at any time. So I mean, there are cases where people have had gone in and out of mental health crisis moratorium 3 or 4 times. And then Regulation 19 deals with a court application by a creditor to cancel a moratorium, which must be made before the end of 50 days, beginning of the day in which the moratorium started and the additional debt was included. And the court may cancel the moratorium, moratorium debt, or cancel the moratorium, instead of any other moratorium debt. And at 19.4, they can require interest to be paid, interest, fees and charges accrued during the moratorium. And 20 is updating information to Secretary of State. 21 is death of the debtor. So that applies. All that applies to both moratorium.
Yes.
And Part 2 is dealing with breathing space, which is not this case. And at Regulation 26.2, you see moratorium continues for 60 days, page 40.
Yes.
And can end as a result of death of debtor or cancel. Regulation 27 deals with midway review and cancellation of breathing space moratorium, which is Regulation 5, 27.5. And then Part 3 is the mental health crisis moratorium. 28.1, where a debtor is receiving mental health crisis treatment. 2 defines the source of treatment. The relevant treatment in this case is E, receiving any other crisis, emergency or acute care or treatment in hospital or in the community. So he's not in, Mr. Forbes is not in hospital, he's in the community from a specialist mental health service in relation to a mental disorder of a serious nature. Is a wide range of people who can apply for a mental health crisis moratorium on behalf of the debtor, including the debtor, and the information that's required and the evidence of a approved mental health professional.
You sidelined quite a lot of this
Yeah.
section of regulation. Do any particular parts of it bear on the issue we have to decide? Issues we have to decide?
No, but they just how the mental health crisis moratorium works.
You can see that.
Yeah.
I think we get the picture.
Sorry?
I think we get the picture from
Yeah.
how it works.
And the duration is 32 to end the period of 30 days, beginning of the day in which the debtor stops receiving mental health crisis treatment. There's other criteria. So those are the regulations. Can I just
ask you about paragraphs 4 and 5 on page 44? One of the things which has to be considered when an application for a moratorium is made is whether the debtor is unable or unlikely to be able to repay some or all of their debt as it falls due. And likewise under 5A, whether they have sufficient funds or income, which suggests that it's looking to future instalments falling due. Why is that relevant if future instalments are not part of moratorium debt? I'm not saying it is, or I'm saying it's not, but I just want to understand it. What's that looking at?
I think it's looking at the debtor's financial position, not just under mental health crisis, but their financial position as well. So, for example, I think it's another. So, if you look at 5, must consider a debt has sufficient funds or income to discharge or liquidate the debt as it falls due, and may have regard to any other factor debt advice provider considers relevant. So it just brings a financial element into whether to grant a mental health crisis moratorium beyond the mental health crisis treatment.
But it looks to the future, to sums falling, not currently due, but falling due, is unable or is unlikely to be able.
And my reading of it is it just if you read 4 and 5 together, it's just creates a financial test as well as a mental health crisis test for a mental health crisis moratorium.
You envisage a situation where somebody may be able now to repay, but may be unlikely to repay at a future date. 4A, doesn't it?
I mean, ex hypothesi, you've built up some debt already, because otherwise you don't need a moratorium on that debt. So why is it relevant to look to the future as well as the past?
Because it's a sort of holistic interpretation of whether the person has sufficient funds to discharge their income or liquidate their debts as they fall due. It's looking at their financial position as well as their mental health crisis position.
does that finish the regulation?
Yes, it does. Yeah.
Thank you.
So I was just going to take you to some key documents. So the facility letter is in the Interbay additional bundle, page 38.
Supplementary bundle.
Yes, sorry, okay.
Thank you. 38. Did you say?
Yes. Tab 5.
Yes.
So the amount of the loan is 1,347,025 plus 16,164, and purpose to remortgage 120 Foxley Lane. 1.6 provide no event of force occurs, we allow you to repay term loan in 120 monthly instalments. It's a 10-year loan.
10-year loan, yeah.
Unfortunately, in my chronology, I said it was a 5-year
You
loan.
did.
I apologise for that. It's an error. I think the judge. So it is a 10-year loan.
Yeah.
I just vote to cross that out. And then provision for interest for 5 years in 1.7.1, and then after 5 years, a LIBOR rate, 1.8 default interest. Security to page 41, first ranking charge over 120 Fox Lane. And the 41 at the bottom, event of default as defined in clause 3 of the standard terms and conditions, which are at page 274.
Do you want us to look at those?
Well, just for the events of default. Page 274. So A, Roman 1 and Roman 3. They'll supply, and if you turn back a page, this is relevant, to Roman I. Not to go on to the lease, but private consent. The next topic I was going to take you is the letter of demand, which is at page 48. And then I was going to take you to the full bundle. So the letter of demand, third paragraph, 1587053, 083.53. And then the particulars of claim in the core bundle at tab 19.
So before you go on, 1.587 million with arrears of 60,000. There's quite a big gap from the amount that was originally lent. So what's the difference made up of? Has there been any capitalisation of arrears in the meantime?
I don't believe so. I'm not aware of any.
So can you help us as to the explanation? we have a redemption
Well, I think
statement.
the arrears are included with the one in the site of 1587.
That's £60,000. I thought the sum loaned was 1.3 million, something.
In the core bundle, there's a statement of account.
Well, I don't think we have the redemption statement that was appended to this letter of 48. We have a redemption statement from a later date, where the higher sum is mentioned.
If you look at the core bundle, at tab 20,
Again, this is at later date, isn't it?
it's got the whole, page 182, it's got the whole account. And the letter of demands on the in March 2019, 1st of March, so that's page 186. There's a 187 on top. And the amounts that have been added are default interest and arrears management fees.
The first, I mean, the first sum on page 182 is more than the original loan. 1,000 more.
So I don't know why that is. There's no
Well,
um,
there's nothing before 1st of February 18.
yeah, so there's the loan was in 2016 July, so it starts from February 2018. I don't know, so presumably there were some arrears building up that turned the original loan amount 1347 to 1424. And you can see after that the way the arrears build up.
Were they capitalised? Or any part of them capitalised? Mr. England shakes his head.
But they're not, because the interest is the same month on month. 5498.08. Whereas after the call in, say page 200, the interest increases month on month. Which would indicate the unpaid interest is capitalised at that point.
Sorry, just help me with that. What is capitalised? Where do we see that? Are we looking at 200? The second account at 200.
Yes, the fact that the amount of the interest, sorry, there are increases of interest. It may be because of a different rate of interest being charged.
Sorry, whereabouts in this account do you say the capitalisation starts?
Well, I had thought page 200 because the interest increases, but looking at it again, it doesn't increase every month. It only increases some months.
Can I just ask Mr. England? Mr. England, is any part of the sum at page 1203, the last sum,
My lord,
capitalised?
no, the loan, paragraph 7 of Her Honour Judge Evans Gordon's judgment, tab 8, core bundle, page 85. Tab 8, 85, paragraph 7. So that reflects what we saw earlier. The appellant fell into arrears in February. That's the beginning of the statement. But the loan was called in, as we saw from the letter of demand, on the 21st of March. So the capital was called in at that point, but at no point has there been any capitalised mortgage arrears in this particular case. That's what the court was asking. And that includes, to answer the court's question, that 1.587 included at that point the 60,000 of arrears. By the time we get to April 2022, which is the date of the moratorium, the arrears had risen to 95,000.
So do you know why the sum of 1.5 is higher than the amount loaned? And the arrears don't seem to account for it.
My lord, I can take instruction and answer that in my submissions, but I'm not sure why it's higher than purely the loan sum itself. It may be. I think there may have been interest that was added, interest payments that may have been added, taken down on drawdown from the loan, but I will double check that.
Next topic we'll take is the tickets of claim, which is a core bundle, tab 19, page 177. And the paragraph 3, the property is believed to be occupied by unauthorised tenants. Paragraph 4a, the tenant's liability to repay is repayable in full and demand on the occurrence of an event of default. Then refers to full demand, and the balance being 1,614,409.24, as shown on the attached statement, which is the statement at page tab 20.
Yeah.
Then it says the property has been let by the defendant in accordance with the requirements of loan terms. Has not been let by the defendant in accordance with the requirements of loan terms, which constitute breach of terms of its mortgage. And the judge understood that to mean the property has been let by the defendant not in accordance with the requirements of loan terms. The amount loaned was 1.363, 6A. And 6B, the loan is repayable in full on demand. This is what I rely on. This is no longer repayable by instalments. And tab 17 is the possession order, page 169.
Yes.
And what I'm going to deal with is in relation to, so on ground 1, in relation to other, is the meaning of arrears in regulation 2.1.
Yes.
And the judge dealt with that at tab 8. Page 80, paragraph 27 of her judgment. Particular paragraph 31. 32. So my submission is that if you look at Regulation 2.1, arrears means any sum other than capitalised mortgage arrears payable to a creditor by a debtor which has fallen due and which the debtor has not paid in the date of the application for a moratorium breach the agreement between the creditor and debtor or breach legislation or rules under which the debtor incurs debtor liability. My submission is that a called-in loan falls under that definition because it has fallen due, it's not paid at the date of the application for moratorium. The reason that capitalised mortgage arrears are excluded relates to if the loan has not been called in. So if the loan's been called in, if there are capitalised mortgage arrears, they form part of a single sum that has fallen due that previously consisted of principal, arrears, capitalised mortgage arrears, interest charges. It's a single sum, and that is the any sum due as when the loan has been called in. The purpose of the capitalised mortgage arrears is before the loan, if the loan had not been called in, if the capitalised mortgage arrears were not excluded from the definition, they might be treated as arrears.
What might be? Because once the interest is capitalised, it's not due, is it? So arrears, the whole concept of arrears is driven by amounts which have fallen due. So capitalised mortgage arrears would never fall due until the principal falls due, would they?
But because they are described as arrears in colloquial terms, in my submission, that's why they need to be carved out of the definition of arrears so that they do form part of the capital.
I mean, is your point that it's what this is to be read as is it's the arrears which were, I think can only be interest, I think, if they're capitalised. That the arrears of interest which once had fallen due shouldn't be included within arrears because they've now been capitalised.
Yes.
Is that your point? Yeah. So as the capitalised mortgage arrears are not due because once capitalised they're not due if the matter's ongoing. But the interest which formerly existed, which makes up the capitalised arrears, was once due, and therefore.
And that's the reason that the reason why they have to be carved out of this definition is so that it's clear that they form part of the capital when a loan has not been called in. But when a loan has been called in, as in this case, there are no capitalised. Even there weren't any capitalised mortgages in this case, but if there had been, they wouldn't form part of the sum. It would just be a single sum due. And my second point is that this definition of arrears has a wide meaning that encompasses the whole called-in capital and secured loan. Because a borrower of a called-in loan requires protection from accrual of further interest and charges during moratorium on that called-in loan. Whereas a borrower of a non-called-in loan does not require the same protection, because those sums are not due and do not form part of the portfolio of debt for which the debtor seeks a debt solution.
Where does the judge deal with this argument about the distinction between called in and uncalled in?
I think it's paragraph 31. Paragraph 31. The judge said that because capitalised mortgage arrears were excluded from the definition of arrears, it made no sense to include the capital within arrears because it meant that capitalised mortgage arrears were not included, but the capitalised, the capital was included. And in my submission, in a called-in debt, where there had been capitalised mortgage arrears, they don't exist anymore. There's just a single sum that is due.
So that's the response to Mr. England's submission as to absurdity. Does the judge address that? Was this argument put to her? And if so, where does she deal with that?
I mean, to be fair, I don't think I put the argument in the same terms as the judge as I'm putting it to the court now.
Right. Where do we go next, Mr. Gunn Cunningham?
So that essentially it's my submissions on ground one, but my friend Mr. Westgate's going to
Come on to deal with the.
deal with that with his ground three.
Yeah. Okay. So. We have other grounds and respondents' notice we're going to deal with. Is that right?
So the ground two, I mean, I could probably take it from my skeleton argument. Page 44, the 4 bundle of part 4.
Yes.
The judge said at paragraph 33, it follows that interest due under loan agreements or charged does not fall within regulation 76A and is not interest on arrears. Therefore, the Deputy District Judge was entitled to make a possession order in relation to any monthly interest payments falling due after the application for a moratorium. My point is that if ground one is successful and the whole debt is a moratorium debt, then there are no interest to be charged on a moratorium debt. So there was nothing, there was no sum that a judge could have made a possession order on.
Right. Yes.
And that's the effect of regulation 7.2 and 7.6a. And my other submission is that under regulation 7.7f, before possession proceedings were started, permission was required to bring these proceedings. No permission was sought or obtained before the claim was issued. And my further submission is that if it's a mixed debt, i.e. if the capital is not within the moratorium, but arrears, non-capital arrears are within the moratorium. In those circumstances, permission was required to bring the proceedings. And
what particular part of the regulation, I may have missed this, what particular part of the regulation do you rely on for that, the second part of that submission? So we've got Regulation 77F prevents any proceedings in relation to or as a consequence of non-payment of moratorium debt.
Well, it's the same, but can I just take you to a judgment of Mr. Justice Mellor in Bluestone Mortgages?
Just make sure I'm asking the right question. You're saying that if you're wrong on ground one,
Yeah.
nonetheless it was still wrong. Proceedings could not be started without permission.
Yeah.
So that's the point I'm asking for your authority on that. And it's going to be. Is there anything in the regulation that deals with that?
No, but I was going to take you to Bluestone Mortgages at Mr. Justice Mellor, who deals at this point.
Right.
At Authorities Bundle 2.
Yes. Tab 18.
Paragraph 1, he refers to a mixed judgment and mixed security.
Do you want to give us the paragraph number you rely on?
Yeah. So this is not a mixed judgment case. It's a mixed security because there was no judgment was made on the Deputy District Judge. It's a mixed security case. So a mixed debt case. So there's the if I'm wrong on ground one, there's a moratorium debt and a non-moratorium debt.
Yes.
So, but what he page 391 he
Yeah.
summarised what the judge below had said.
Yeah. Can we go to the analysis at 396?
Yeah.
Is that where we're going to find help?
So he goes through what the judge has decided, and then he says at page paragraph 61, if the claimant's case on this appeal is correct, the claimant would have an automatic right on the regulatory force of judgment order regarding a non-moratorium debt for security eligible for non-moratorium, whilst being unable to take either step in relation to a moratorium debt during the moratorium period. When I say automatic right, it means that no permission is required from the court before those forces such taken, so there is no oversight of whether they would or might affect the mental health of debtor. Stripping out the technical language of the regulations using the facts of this case example, while the debtor is in mental health crisis treatment, the claimant would have an automatic right to enforce as regards the approximate £300,000 debt, but not affect the approximate arrears. On the C's case, the permissible enforcement is necessary until eviction from and then sale of the family home. In my judgment, there are very few events which can be more detrimental to the debtor's mental health than those. So a purpose of interpretation points firmly in favour of interpretation reached by the judge. And that interpretation is at page 391, paragraphs 106 to 109. And 392, 112 to 114.
One 113 in particular, perhaps. Yes.
So that's ground 2.
Yes.
Ground 3. The judge, as an alternative, said that the unauthorised occupation was a ground for possession. That point was raised in the respondent's notice as an additional ground. And my submission is that essentially that the whole proceedings were null and void. If I'm right about the moratorium point or the mixed debt point, the whole proceedings were null and void under 712.
Right.
Because they were an action contrary to Regulation 77F, which is start any legal action proceeding as a debtor relating to as a consequence of non-payment of moratorium debt. And in my submission, you can't sever out a claim in relation to unlawful letting from an action that is null and void because it's brought in breach of, as well as Regulation 712.
Right. Does that deal with the grounds? Your grounds?
And I'm happy, because of the time, I've dealt very briefly in my skeleton argument with each of the points in the respondent's notice. I'm happy to deal with that in reply.
Yes, I think that would probably be sensible in view of the time. If you're happy to do that,
Happy
Mr.
to.
Concoin. Anything else, Mr. Concoin? Okay, thank you very much. Right now, Mr. Wingate, what do you want to say?
Well, I'm going to confine myself to the moratorium debt point.
Yes.
We adopt what's been said about capitalised mortgage arrears. Capitalised mortgage arrears by Mr. Gunn Cunningham, that was a point that was raised below in the Seculink case.
Yes.
I'll just give you the references. The judge's answer to our point was paragraph 28 of the judgment. Our answer to the judge's answer is in our skeleton argument at paragraph 52. I probably won't have time to go.
All right. Well,
expand on that.
focus on what
Yes.
you want to say, and we'll see where we have some time to look at that briefly.
What I was going to cover is briefly some points about the principle of legality, which is an interpretive principle, which and then to come on to deal with principally Regulation 5.4. On the first point, principle of legality, we use that as an umbrella term to cover the group of submissions in the respondent's skeleton arguments, paragraphs 20 to 28 and 43 to 50. And in response, briefly, we have 4 points. One is that Sir Anthony Mann's approach to this at paragraphs 20 to 1 of his judgment was correct. He didn't ignore the principle, but he gave it limited weight. Secondly, and the related point, the principle of legality, while important, doesn't have the reach which is claimed. Thirdly, and this is a related point, that there's no rule of interpretation, that the least intrusive reading must always be adopted where there is something that impinges on, in particular, property rights here. And fourthly, the outcome all depends on the context, and the broad principles relied on by the respondents have limited application in a case like this, and I'll develop that. As far as the first point, the limits of the principle of legality is usually used to describe an approach to general words that don't in themselves authorise derogations from fundamental rights, and they won't then likely be construed as doing so. And very often, it's something that appears in the context of enabling powers to allow delegated legislation to be passed. And the passage that my Lord drew attention to at page 402 of the authorities bundle is just such a case. And that also appears.
This is your authorities bundle.
No, it's the Interbay authorities bundle.
I'm so sorry.
You asked a question about whether this was a case that engaged.
So this is
in
the
strict interpretation.
this was in because there are bits of Benin in both authorities.
No, exactly, yes. It's
It's
because
Gunn
I'll
Cunningham's.
have the footnotes and those done.
Okay.
So that's.
So 402. Yeah, oh, that's right. Yes.
But I simply raised it because it's something my Lord raised a question about.
Yeah. So just say what was your submission applies?
Well, the point is that it's actually an example there of an enabling provision.
What is?
The example, the passage that you were taking.
There are certain types of enabling powers.
That's right. Yes, exactly, and so and that's really the territory where the principle of legality very often has effect. And the examples that are given by the respondent are all ones where either it's general words like that, or where the attempt is made to imply a power to intrude on fundamental rights, and unsurprisingly, the courts are reluctant to do that. What they don't help with is cases like this, where the Parent Act plainly does contemplate that rights will be interfered with, and the question is not can they be interfered with, yes or no, but the extent to which any interference should extend.
Well, as I understand the respondent's submission on legality, they accept that. It's the issue is when you consider the extent.
No, indeed,
of any restriction of rights, that requires a restrictive interpretation.
Yes, but
enabling power.
The overriding principle, and I'll give you the reference, is Bennion 27.1. It's footnote 15.
This is now back to your Bennion, is it?
Yes, it is. But I'll just give you the reference and then read a very short passage. I won't take up time going through a paper. It's 27.1. The Seculink Authorities, page 158. And it's a quotation from Lord Dyson in AJA and Commissioner of Police, where he says the principle of legality is an important tool of statutory interpretation, but it's no more than that. When an issue of statutory interpretation arises, ultimately, the question of the court is always to decide what Parliament intended. And leading on from that...
Sorry, which footnote?
It's footnote 15.
Oh, yes. You've marked it.
And leading on from that is our third point, I think, which is that there's no least intrusive principle or rule of interpretation. That the respondent claims, and this is paragraph 44 of their skeleton, that Parliament is presumed to have intended the least interference possible, which the statutory language allows. That's in a case where there is some intrusion on what they describe as fundamental rights. Allowing for the time, I'm simply going to make the point that the cases relied on them don't make that out. They talk about not going further than the language requires, but that begs the question, well, what does the language require? And notably, the respondent hasn't been able to cite any case where the supposed least intrusive principle has been applied in practice to produce an outcome that's driven by that consideration. So in other words, there's no authority that supports the kind of reasoning advanced by Seculink at their paragraph 44, to the effect that the court should ask what reading least interferes with common law rights, and then adopting that reading for that reason. And indeed, such authority as there is, tends to go the other way. So we would ask you to look at, firstly, Cadogan and McGurk, which is tab 4 of the Seculink authorities, page 49 of that bundle. It's a leasehold enfranchisement case about the meaning of appurtenances. And the passage that we highlight is page 53 of the authorities bundle, which addresses a comment taken from Methuen, Campbell and Walters that a man is not to have his property compulsorily acquired except by plain language. But the judgment then goes on to say that's not the approach that's been adopted since, and goes on to say it would be wrong to disregard the fact that while the 1993 Act may to some extent be regarded as expropriatory of the landlord's interest, nevertheless it was passed for the benefit of tenants. And that's at 54B.
Yes. So just when we're looking about the principle, like hearing these general submissions,
yes,
I'm just reminding myself of the actual phrase in the statute we're looking at, and it is the phrase accrual of further interest or charges, isn't it? That's the phrase which all this is addressed. to, isn't it?
Well, it's well the phrase which that's the scope of the enabling power.
Yes.
It's
Well, that's the scope. That's the so insofar as Mr. England's submission has any legs, that's what we're looking at, isn't it?
Well, it's that, and it's also 6B, which in the Parent Act, which is protection.
Protect individuals in debt from enforcement action.
Yes. So we see that Regulation 7 does both of those things. It protects against interest, and it protects against enforcement. And interest there is interest on or in respect of the debts that go into the moratorium is the way it works, and also to protect against enforcement in respect of those debts. But Lord, if I can just finish on this general point, the other authority.
There is a concept of least intrusive measure when we're looking at proportionality in interference with property rights under the European Convention, but you say there's no read across.
It's no. The least intrusive principle in proportionality isn't one that's applied rigorously in the sense of if there's some logical thing you can do that's less intrusive, then you have to do that. So we resist the notion that that's a hard and fast rule anyway. But in any case, it doesn't assist on interpretation. And the authority, the particular authority I refer to that is HHJ Medway, which is the next one in the bundle.
Yes.
Which is tab 4, and that was a case concerning whether debentures meant any debentures or any of the ones in which, with respect to which a receiver had been appointed, and if the former, then preferential creditors took priority, and therefore that was more intrusive in respect to the debenture holder's rights. And despite that, and despite the fact that the judge held that either construction accorded with the language of the section, Mr. Justice Neuberger opted for the more intrusive reading by following a classical contextual exercise, and we see that at paragraph 63, page 63, where at letter G, he says, well, as I said, either construction accords with the language of the section. It seems to me the construction advanced by the preferential creditors is a more natural meaning, and then he goes on to give a series of conventional reasons for that.
Yes.
But he then, at page 64C, deals with a particular argument that was raised on behalf of Ford, based on a canon interpretation in the Cannon Brewery case, which is broadly to the effect that is asserted by the respondents. And then he goes on to say, Ford's interpretation could be said to involve that section interfering with property rights to a lesser extent, because it's not without force, doesn't regard it as particularly strong. And
Where is this, sorry?
it's
65.
65 letter D. And it's really the sideline passage.
Yes, that observation was after he'd found 5 reasons
No, indeed.
for preferring a broader interpretation.
It's fair to say, and perhaps a corrective as to applying the broad principles in themselves, that in all these cases.
So it's a case where the broad the principles led him in a certain direction. He didn't find the principle of legality as cited him in that case to be sufficient.
No, indeed. And so we don't say that these are irrelevant considerations, but they need to be put into place. They're not determinative, and they don't displace ordinary principles of interpretation. And so that really brings us to the context, and the context here is that, as the judge recognised, the Act authorises interference in property rights within the parameters set out in the legislation. And that's a necessary consequence of a scheme designed to provide respite for debtors. And we do say it's important not to overstate the impact of the intrusions. The respondents each complain of a loss of interest, and they each complain of inability to enforce, but those are necessary and inherent features of the scheme. And the reality is that their main objection does appear to be that the length of the time over which that operates, and they each point to the length of the moratorium in this case. But that, we suggest, shows something of a mismatch between what the respondent's real complaint is and how it bears on interpretation, because what they're seeking to interpret or read down are the types of debt that go into the moratorium, and there's only a limited connection between that and the length of time for which the moratorium bites.
Limited connection.
Limited, yes.
Why do you say that?
Well, because the implication seems to be that intrusions of this kind would be acceptable, and might be what's intended if one is looking at a shorter period of moratorium, but then not if one's looking at a longer period of moratorium. But what one then has to do is ask yourself, well, what's the object of the scheme? Because the scheme is, as we've seen, one that covers breathing space moratoria, which can only last 60 days. And one can't assume that mental health crisis moratoria will last for a significant period. And indeed, there's material before the court in the impact assessment that suggests that the median mental health crisis moratorium was taken to be 64 days, for 34 days in treatment and 30 days.
But it's by definition, a mental health crisis can be very brief, or can be indefinite, chronic, long term.
No, of course it can. The existence of a median assumes that there are cases above the median, of course. But the point is that the balance struck by the regulations is one that has to cover all cases, and very many of those cases, and indeed a vast majority of them, will be much shorter because the breathing space moratorium will be much shorter. And we suggest it's wrong in principle for the meaning of the regulations to be driven by focusing on the facts of what might appear to be hard cases, where the moratorium ends up happening to last much longer, or where the amounts happen to be larger. It's also right to point out that the interferences, such interference as there is counterbalanced by the fact that there's a right at the outset to challenge the moratorium on various grounds, and there's a right at any time to apply to enforce. There's a duty on the part of the debt advice provider to satisfy themselves that in the case of a mental health crisis moratorium, the debt is still undergoing crisis treatment. And there can also be cancellation under Regulation 34, where information was provided that was inaccurate. And so there are a number of opportunities that certainly Seculink could have availed themselves of, and they didn't do so at the beginning. And while on this point, it's perhaps important to note that there are reasons why mental health crisis moratoria operate differently from breathing space moratoria. I'll simply give you the reference for the time, which is that it's perhaps most fully set out in the Treasury response to the consultation, which starts at page 468, I think, of the Interbay bundle. And that explains that because of the characteristics of people who will go into mental health crisis moratoria, although the protections will be the same, a number of the requirements won't be the same. And that explains, for example, why they don't have to pay ongoing liabilities, why they don't have to keep in touch with their debt advisor, and why they can have moratoria.
Could you just give the reference again? Page 468.
Yes.
Paragraph.
It's sorry, no, just it's, I'm sorry, I've given you the wrong reference.
Yes.
It's, it's paragraph 714 at page 534. That's the explanatory memorandum.
Yes.
And
I thought you wanted the Treasury response.
yes, it's 474.
474.
Yes.
That's further on.
Yes, and it's under the heading "Breathing Space for Those in Mental Health
Yes.
Crisis Care."
Right.
It's a fairly lengthy passage.
Yes. Well, we have. We'll just sideline that and look at it.
And so, if I can come to the arguments on Regulation 5.4a, the question here is whether the whole amount due under the loan agreement, which we signed at page 122 of the Seculink bundle, is arrears in respect of secured debt.
Yeah.
And what we say is that when the regulations are read in context, they produce a clear answer.
Now, are you going to take us? Do we have the regulation in front of us while you're making this submission?
It's in tab 2 of the tab 4 of the Interbay bundle.
Right. So we've got.
And the ones we're going to be looking at principally are 5.4 and 2, the definition of arrears in 2.
Yeah. Okay.
And then we'll have to come and look at 7. But not right.
So yeah, we are page 20 arrears. Yes.
Yes. So
And 5.4.
the closing words of 5.4a are arrears in respect of secured debt.
Yes.
And we've got 6 points to make on this. First is the starting point, is the breadth of the definition of arrears in Regulation 2 that has to be read into Regulation 5.4a. And when you do that, and taking out immaterial words, you get, and I've set this out in our skeleton at paragraph 51c, so to avoid the need to write it down. It's the definition of arrears, i.e. any sum other than capitalised mortgage arrears, which has fallen due and which the debtor has not paid in breach of the agreement between the creditor and debtor. Then it comes back to the wording of 5.4, in respect of, and then you read in the definition of secured debt. So it says, has not paid in breach of an agreement in respect of an agreement under which the creditor provides credit to a debtor and the agreement provides for the obligation of the debtor to repay to be secured by a mortgage on that. And so to cut that down to the essential ingredient, it's any sum in respect of an agreement. And we suggest that there's no room to read that in any other way than that the phrase includes whether any sums due under the agreement, whatever else it covers. And it follows from the legislative decisions both to use the term any sum in the definition of arrears and to define secured debt by reference to the agreement itself. Our second point is that it's important to note that what we suggest is an obvious reading isn't the accidental outcome, as sometimes happens, of applying a general definition in an atypical context, where other indicators show that some ordinary or other reading should be applied. Because the only places where the definition of arrears has any work to do in the regulations is in relation to secured debt. It appears in Regulation 2 itself, the definition of capitalised mortgage arrears, Regulation 5.4a and Regulation 7.9, which deals with, also deals with arrears, mortgage arrears. And there's one outlying reference to arrears which clearly doesn't have anything to do with this, about Welsh rent payments. But it's therefore, we say, improbable in extreme that the drafter intended to cut down the breadth of the words any sum simply by the use of the words in respect of in Regulation 5.4. And the first difficulty with that, and that there are two, this is our third point, is that that's not, we suggest, what in respect of normally conveys. Before Sir Anthony Mann, the choice was presented as being between arrears on or arrears of, as being paraphrases of that phrase, or both. And while we accept that those might be useful ways to frame the point, they create their own definitional problems, and they can't be a substitute for the statutory term. In respect of is a connected phrase that in this context links any sum with an agreement. It's capable of and would normally cover a range of links between those things. And as a matter of ordinary language, it covers any sum the debtor is required to pay under or in connection with the agreement. And the judge, we suggest, recognised that substantially when he accepted that the respondent's reading was strained of arrears on. And that is all the more so when you consider what would happen if you insert arrears on into the reading of the statutory definitions. Because what you then get is any sum on an agreement. And that we would suggest is really substantially the same as in respect of an agreement. It covers the sums due under the agreement. We get support for this from the fact that, again, as the judge also accepted, other parts of Regulation 5 plainly used in respect of in the same way. We've dealt with that in our skeleton argument, and I won't take up time doing that, going further into that. But more fundamentally, and this is our fourth point, the respondent's reading of in respect of demands that a distinction be drawn between the arrears and the thing that gives rise to them. Sir Anthony Mann expressly referred to that at paragraph 27 of his judgment, and the respondent's skeleton, paragraph 49, says that the arrears arise out of, but do not include the secured debt itself. And the difficulty with that is that the statutory language doesn't allude to that concept, and it provides no way of distinguishing between those two things. The statutory language doesn't talk about what arises out of the secured debt, but on that which is in respect of the whole agreement. And the secured debt and any interest or charges will typically arise out of and be in respect of the agreement. What other basis is there for them to be charged? And so in order to make the language fit the respondent's account, it's necessary to read some limitation into the definition so that any sum in respect of an agreement doesn't include the principal advanced or something of that kind. But the statutory language, we suggest, makes that impossible. And if anything, the reference to the obligation to repay in the definition of secured debt means that the obligation to repay the principal is indeed exactly the kind of thing which is intended to be covered by the wording any sum. And our fifth point, is a related point, is that neither of the judges below nor the respondents address this problem other than to assert that the distinction exists between arrears and the thing that gives rise to them. But in the absence of any criteria in the regulations by which to decide what parts of the agreement are secured debt itself and what arises out of it, the problem we suggest can't be solved by interpretation because the court doesn't know what yardstick to apply. And so it's not simply a point that any possible limitation involves reading in too much into the regulations. It's simply the exercise can't be done. And it's instructive that the respondent's reading, or the respondent's reading, we suggest also can't sensibly accommodate the paradigm case of a repayment mortgage. And it's instructive that in their skeleton, paragraph 37, they say that capital payments or payments of interest will become due for payment. And if those instalments are unpaid on the date of initiation, there'll be arrears on a secured mortgage debt. And a similar point's made in the Seculink skeleton in the county court. And Interbay's case before the county court was also that arrears relating to capital or interest.
So repayment, a repayment mortgage, which includes an element, each repayment including an element of the capital.
That's right. And so the respondent's cases appear to be, well, the capital comes in as arrears. But that then raises, well, how does that happen? If the distinction is between the principal sum, which gives rise to the arrears, and the arrears themselves, how can the capital itself?
So you say there's no logical distinction between the repayment of a capital under a repayment mortgage and a requirement to repay once it's been called in.
No, indeed, and if you once you accept that capital is in the
capable
mix,
of being,
which it has to be in order to maintain the respondent's common sense reading of arrears. Because on a repayment mortgage, when you talk about what's in arrears, you say, well, what did you have to pay this month? and if you don't pay it, those are the arrears.
Your
And-
case is that the arrears includes both.
Okay, so the arrears includes whatever is due under the agreement. But once the respondent accepts,
It's due on, your case is it's due under the agreement under repayment mortgage in the conventional sense.
then yes,
And once it's been called in under the terms of an agreement, it's similarly covered.
no, exactly. But the point is that the respondent's case sells the pass on this, because once it sells the pass on it, because once they accept that capital is included,
Can be.
then the distinction between the arrears and the thing breaks down, and it produces a strange and we suggest irrational result that the question whether something is in arrears doesn't depend on the quality of the obligation that's been breached, but on the periodic nature of the instalments.
Yes.
And that has a further odd result that something that's payable by 2 instalments would be capable of being in arrears, but something payable by 1 instalment isn't. And it raises all sorts of questions about what happens if you have a number of instalments. Is it arrears until you get to the last one, and so on. And all of those create confusion that the court can't know how to amend or to read into the language, because we don't know whether any corrected interpretation should focus on the periodic nature of the payments, or the kind of payments, whether it should be principal, or whether it should be capital, or whether there should be some other way of defining it. And once you go down that route, the respondent route, then you end up risking making the application of the regulations, which ought to be a matter of substance, turn on the precise way that the agreement was worded. And that's instructive in our case, where the original advance or the sum due of £260,000 had £60,000 deducted from it at the start, which covered £20,000 interest, and then the remaining £40,000 fees and charges. And so faced with an agreement like that, what's the principal, what's the capital, what's the bit that falls in and what doesn't? And the regulations simply don't help you on that. The reason they don't help you is that they have deliberately chosen regulation, the broad definition in Regulation 2, which is incorporated in Regulation 5.4.
Well, thank you very much, Mr. Westgate.
I'm
There's
afraid
a
I
bit
haven't
more.
done
There's a bit more. I think we're catching up, Mr. Westgate. I'm optimistic that we're not going to take too much longer, but I think we'll rise now.
Yes.
Are you going to deal with capitalised mortgage arrears?
I wasn't going to it's in our skeleton. I've got a couple of short points to make on it.
Yes.
There were a couple of points I did also want to pick up on the difference between owing and due and ongoing liabilities.
Yes. We'll have a chance to refine what you want to say
I
over
will,
the shorter chat.
I'm very conscious of the time, so
No.
I'll shorten it over the shorter chat.
I think we're not doing too badly, he says, hopefully not too optimistically.
Mr. England,
My lord, sorry, we're just concerned that we will be as quick as we can, but obviously we'd planned to start at 2 and Mr. Morris has to speak as well, and then there's a reply. And we'd understood and agreed carefully with the respondent.
Well, we lost some time this morning when we were dealing with the preliminary matter.
Of course, my lord.
My assessment is we have made up some time. Mr. Westgate's gone very quickly, but his submissions are at the centre of this case.
Of course, man.
And we want to give him every opportunity to say what he wants to say.
I finished what I'm saying on 5.4a, but I do.
You've got some further points to sweep up.
Yes.
I don't imagine you'll be more than 10 minutes or so.
I'll do what I can to keep it up.
Thank you very much.
Court rise in favour.